we couldn't hear some of the questions you were asked just now at that press conference, one of which was, you said, we'll be back in mistrial mode, something about an interview that was barred. What were you talking about?
Well, they were asking about what's been labeled false alibi evidence, and I believe that Judge White a couple of years ago said that they shouldn't really get into that. If they want to get into that, they're going to have to approach the judge, and we'll have to talk about it.
And you're telling me what you're talking about. I think I know what you mean by false alibi. You're talking about Stacy's statement to the police.
Stacy's statement that Drew was in the house essentially all night, and we don't. And it's not false, by the way.
A statement that she gave the day Savio's body was found, crying with Drew, her husband, 12 inches from her, in the basement of her home, like she really could be honest.
Well, why couldn't she be honest?
Because he was looking at her, staring at her.
Well, that presumes that he did something.
Now, Neil Shorey is expected to testify, and Judge White did rule his statement admissible.
Right.
And he's going to say that Stacy told him something very different, right?
What Neil Shorey is going to testify differs from what Stacy supposedly told the police, but I think that when it comes out that you're going to find that there's nothing to confirm it. There's no phone records. We have phone records. There's no phone records to confirm what Neil Shorey says, and he's just another person who was looking for the limelight.
And what he said was?
You have to wait for court.
I will tell you what he says. Stacy told him 2 months before she disappeared, and she was looking to leave her husband because he was being abusive to her also. She said that Drew was not home in the middle of the night Kathleen Savio was killed, and that before her body was discovered, he came home wearing dark clothes, carrying a bag of women's clothes, and they weren't her clothes. And put them in the washing machine, correct?
Something like that, yeah.
All right, that's pretty damaging.
It is pretty damaging, except that she also says that she kept calling him, and we have the phone records, and there's not a single call. And if you think about just the details in that, why, if you did something like this, would you bring clothes home? Would you wash them? Why wouldn't you just get rid of them? And also,
get rid of them?
also
she
away. Was not being abused. I don't know where you get that from. Nor was Kathleen. You know, I keep hearing about these 18 calls. These 18 calls, 16 calls were he hasn't brought the kids home in time, and 2 of the calls were Drew calling, including when Kathleen was physically assaulted.
I agree with you that a number of the calls where the children weren't home in time, but it is not true that 16 were, and it's not true. He did have her arrested twice, but there were other calls of him taunting her and threatening her.
Well, that's not abusing. You know, abusing is when people say abuse, they talk about physical violence, and let's be clear on this. There is no evidence that he was ever physically violent towards her.
Would you not agree that there can be psychological abuse of a person?
Sure, there can be psychological abuse, but when you're talking about domestic abuse, I think that that's just a bad marriage.
Okay, so let's not talk about the domestic calls. I said he was abusive to her.
Well, abusive is all relative. You know, people don't get along. It happens.
This is a man who followed his wives, who terrorized them. He cut a hole in her family room wall. This is Kathleen.
I haven't heard about that in court.
Well, it's happened. It's a fact. You fought hard to keep it out. It's a fact. Correct?
Okay. We're going to try this case based on the evidence that's admissible in court, Beth, and you can go on TV and talk about whatever you want because you're not restricted by things like reliability, rules of evidence, and that's the difference.
Yeah, but you can talk about that too outside of court.
Well, there's no reason to talk about it because the judge has found it unreliable.
All right, let me ask you about the towel. There has been a lot of evidence about the towel on the side of the tub.
The blue towel?
Yeah.
The blue towel that was there and then wasn't there and was there.
Well, it was there in photographs. Can you describe the position of it in the photograph? Because we don't have that photo.
Sure. It's laying on the side of the tub, basically next to where you would turn the water on and off in the faucet is.
Is it draped over the edge or is it folded?
No, it's folded, neatly folded.
It's not draped over the edge.
It's a neatly folded towel, and again, here's where you can choose to believe whatever you want. The Ponarellis never say anything about the towel until 2008. And the the emergency medical technicians who came, the paramedics, all were quite clear in saying the towel was not there. If the towel wasn't there when they were there, then Drew couldn't have planted the towel. And what does that do to their staged crime scene?
Yeah, but don't they say they just don't know where couldn't he have gone back upstairs?
Well, everyone says he didn't go back upstairs. You know, you have 2 biased people, her best friend, who says, yeah, I think he came in. She says it years later. And then you've got these witnesses who are trained to observe these things, who come to court and say, The towel wasn't there. He didn't come in the room. In fact, he was out of the house when we left and gone.
Well,
and you know where he was? I believe he was back at the police station.
They didn't all say that, but some did.
Well, no one said he was in the bathroom.
Not when they were there. What about this motive evidence that you continue to fight to keep out? That isn't finished, right? I mean, the judge...
No, the judge still has to make a final ruling on that.
Right. How can you possibly think that the jury is not entitled to hear about the upcoming divorce settlement and what was at stake, and that his back was up against the wall, he stood to lose a lot, and that's what motivated him to kill her? I mean, how do you think that's not relevant? Because
the Illinois case law says it's not relevant, and greater minds than I have decided it's not relevant. That's why. Because it's not. Because for purposes of the divorce proceeding, she was considered a living person. And a judge made a determination. She was represented at that time. Her estate was looking out for her best interest, and a judge looked at it and said, this is fair and equitable. Whatever the settlement was, it was blessed by a judge, and no one to this day has gone back and said that was not a fair settlement. So why should this jury be able, hold on, Beth, why should this jury be able to second guess what a judge did? Jury's not an appellate court.
One of those pieces of property, though, would have been at issue at the divorce settlement and would not have been at issue post-mortem after she died, and that was the house, right, which they own jointly with a right of survivorship. So she's dead. It's not even at issue once she's dead. It's his.
I do not believe it was owned in joint tenancy.
Right,
the house. Because it wasn't.
That's what I found. I saw that.
It wasn't owned in joint tenancy, and I believe that the house was still taken into account. It was owned in tenancy in common.
Which means it's still up.
Which means it was still part of the estate, the divorce estate. Sorry.
It was
you keep plugging away, though. You could be the next Nancy Grace at this rate.
All right. So, and you mentioned Furman was on Fox News, and he mentioned that they reached an opinion about.
Furman says that when he and Baden first read Dr. Mitchell's autopsy, they both decided it was a homicide. So that means everything that was done after that was staged for TV. We're going to look into that.
You would agree, would you not, that when you're determining the manner of death, you often can't look at just the autopsy. What's on the table there? The body.
Would agree with.
Okay? You got to look at the circumstances. And Furman and Baden had a circumstance that Mitchell didn't have, or the coroner's jury didn't have: the disappearance, presumed death, of Stacy. And they had more information.
So, do you think that the disappearance of Stacy or the presumed death of Stacy changed the physical evidence?
I just told you, when you're determining manner of death, you look beyond the autopsy table.
So now you're looking at odds. Well, his first two wives are still alive, right? Nothing wrong with that. So now we're looking at the odds,
and we're like, the second wife, which you barred. There's stuff about the second wife which you barred.
All right, but we're like, Stacy disappeared, so therefore that makes it more likely that these bruises were caused differently, that she didn't slip in the tub. How does that change? Does it change the toxicology? No. How does that change anything?
No. It focused maybe more attention on what Susan had to say.
Made it a better story. Made it a better story.
It is a good story.
You mean what Susan never said until after?
That is not true.
That is
Susan,
true.
Oh no. The coroner's jury knew it. The coroner knew it and told her, you need to talk to the police about it. We're just here to determine manner of death. Susan was suspicious immediately.
She was suspicious.
And she told them what her sister had said, that he told me he could kill me and make it look like an accident.
Did she tell a cop?
She told the coroner.
She told a cop?
I don't know the answer to that. Do you know?
Do you
really know for sure?
I do know for sure. I've actually read the discovery.
Can I have it?
No.
All right. What's up for today?
Today they're going to call the crime scene investigators and the assistant coroner.
Who's the assistant coroner?
Vanover.
And what, because Mitchell's not here?
No, because he went to the crime scene.
Okay. All right. And what do you expect him to say?
Not much.
All right. Well, thank you for taking the time to talk to us. I'll debate you anytime. If I could have that discovery, I'll be more informed.
And I'll be disbarred.
Okay.